Everyone knew him only for his muscles and action movies. But when Dwayne Johnson stood up in the Supreme Court that day, he was about to reveal a secret he had kept hidden for 20 years. A criminology degree from the University of Miami, secret law courses, years of constitutional studies. Chief Justice John Roberts was dismissing him as just an actor, unaware that standing before him was a true legal genius. Rock's first sentence alone would completely change the expression on Roberts's face. "Mr. Chief Justice," said Rock, his voice powerful enough to fill the courtroom yet respectful, "may I speak to you about the original intent of the Equal Protection Clause in the 14th Amendment?" What happened next would shock both Roberts and everyone in America's most prestigious courtroom. Before diving into the details of this extraordinary legal showdown, don't forget to like this video and subscribe to our channel for more stories of Hollywood's most surprising hidden geniuses. Roberts' World, Prestige and Prejudice. Chief Justice John Glover. Roberts Jr. stood at the pinnacle of America's legal system. Harvard Law School graduate, former Supreme Court clerk, legal counsel in the Reagan and Bush administrations. At 70, Roberts had been presiding over America's highest court since 2005. His bearing in the courtroom reflected authority born from decades of experience. Known for his sharp intellect, meticulous legal analysis, and strict adherence to protocol, Roberts believed very few could challenge him. His prejudices about Dwayne Johnson standing before him that day were typical. Yes, Johnson was a successful actor. Yes, he was beloved by the public. But in Roberts's eyes, he was just another Hollywood celebrity, not someone who could understand complex constitutional matters. He would soon learn what a massive mistake this assumption was. Rock's secret journey. From muscles to law. The world had known Dwayne "The Rock" Johnson in different incarnations throughout different eras. First as WWE's charismatic champion, then as the muscle power of the Fast and Furious franchise, later as one of Hollywood's highest-earning actors, a superstar who topped Forbes' 2023 list with $270 million in earnings. But nobody knew that Rock's true passion lay elsewhere. His dual degree in criminology and physiology from the University of Miami in 1995 was just the beginning. When his NFL career ended due to injury, most people thought he transitioned to wrestling. In reality, Rock was secretly spending his time with law books. "People only know me for my muscles," he had confided to his closest friend Kevin Hart. "But I want to understand what real justice means. I want to learn how the system works, the true meaning of the Constitution." Starting in the 2000s, he began spending time between film shoots at Georgetown University Law Center. He took private lessons on constitutional law, civil rights, and the criminal justice system. He worked one-on-one with renowned constitutional expert Professor Lawrence Tribe. While his Hollywood career soared, Rock was secretly transforming himself into a genuine legal expert. He memorized Supreme Court decisions, read Constitutional Convention minutes, and researched the Founding Fathers' original intentions. The Case Foundation. Equal protection versus systemic discrimination. The case before the federal court touched on one of modern America's most sensitive issues. Johnson versus Federal Bureau of Prisons addressed systematic discrimination within the federal prison system and violations of equal protection principles. Rock had discovered through his charity, the Rock Foundation, which closely monitored the conditions of youth in prisons, that race-based differential treatment was being systematically applied within the federal system. Specifically, young Black and Hispanic inmates were receiving harsher disciplinary actions, longer solitary confinement periods, and fewer rehabilitation opportunities compared to white inmates for identical infractions. When Rock decided to file a federal lawsuit challenging this systematic discrimination, the legal establishment initially dismissed it as a celebrity publicity stunt. The Department of Justice assigned their top attorneys, confident they could easily defeat what they saw as an amateur legal challenge. They had no idea what they were up against. The setup. Washington, D.C. Federal Courthouse. The ornate courtroom of the U.S. District Court for the District of Columbia was packed beyond capacity. Media outlets from CNN to Fox News had sent their top legal correspondents. The gallery was filled with civil rights activists, legal scholars, and curious onlookers wanting to witness this unusual confrontation. At the plaintiff's table sat Dwayne Johnson, dressed in an impeccably tailored navy suit, his massive frame somehow managing to look both imposing and respectful. Beside him sat his legal team from the prestigious firm Williams & Connolly, though Johnson had insisted on representing himself for key arguments. At the defense table, the Department of Justice had assembled their A-team. Leading them was Deputy Attorney General Lisa Peterson, a Harvard law graduate with an impeccable record in constitutional litigation. Behind her sat federal prison officials and government lawyers, all confident this would be a straightforward victory. Chief Justice Roberts, presiding over this case due to its constitutional significance, had been assigned through the special constitutional review process. His reputation for intellectual rigor preceded him, and his skepticism about celebrity involvement in serious legal matters was well known. First contact. The underestimation. Mr. Johnson, Chief Justice Roberts began, his voice carrying the weight of judicial authority. This court appreciates your humanitarian concerns. However, constitutional litigation requires extensive legal expertise and understanding of complex precedential frameworks. Do you truly believe you're equipped to argue such sophisticated matters before this tribunal? The question hung in the air like a challenge. Roberts's tone was polite but condescending, clearly expecting Johnson to defer to his professional legal team. Rock stood slowly, his 6 feet 5 inches frame commanding attention. Mr. Chief Justice, I understand your skepticism. Many people see me and assume I'm just another entertainer playing lawyer. But I'd like to address your question by first discussing the historical context of the 14th Amendment's Equal Protection Clause, specifically Section 1, which states, "No state shall deny to any person within its jurisdiction the equal protection of the laws." A murmur rippled through the courtroom. This wasn't the fumbling response Roberts had expected. The framers of this amendment, Rock continued, particularly Congressman John Bingham of Ohio, intended this clause to ensure that state and federal institutions could not systematically discriminate against individuals based on immutable characteristics. I believe the evidence we've compiled demonstrates exactly such systematic discrimination within federal prison facilities. Roberts's eyebrows raised slightly. The response was articulate and legally grounded, but he wasn't convinced yet. Testing the waters, Roberts probes deeper. Mr. Johnson, Roberts continued, his voice taking on a more serious tone. Citing the amendment's text is one thing. Understanding its jurisprudential evolution is quite another. Are you familiar with how the Supreme Court has interpreted equal protection over the decades? This was the kind of question that separated legal amateurs from serious practitioners. Roberts was testing whether Johnson had real depth or was simply reciting prepared talking points. Rock nodded confidently. Absolutely, Mr. Chief Justice. The court's equal protection jurisprudence has evolved through several distinct phases, beginning with the separate but equal doctrine established in Plessy v. Ferguson in 1896, moving through the gradual erosion of that precedent in cases like Missouri ex rel, Gaines v. in Canada in 1938, and culminating in the landmark Brown v. Board decision in 1954. Roberts leaned forward slightly, his interest genuinely piqued. Continue. The Warren Court era saw the development of the three-tier scrutiny framework, Rock proceeded, his confidence growing. Rational basis review for general legislation, intermediate scrutiny for gender-based classifications established in Craig v. Boren, and strict scrutiny for suspect classifications like race, established in Korematsu, though ironically in upholding rather than striking down discrimination. The courtroom had fallen completely silent. Legal reporters were frantically taking notes, and even the government's attorneys were paying close attention. Roberts's surprise. Real legal knowledge emerges. Roberts was now genuinely intrigued. This wasn't surface-level knowledge. Johnson was demonstrating real understanding of constitutional law evolution. But he decided to test even deeper waters. Mr. Johnson, you mentioned strict scrutiny. Can you explain how this court should apply that standard to your specific allegations about federal prison conditions? This question required not just memorized case law, but the ability to synthesize legal principles and apply them to novel factual situations, the hallmark of sophisticated legal thinking. Rock's response would prove his true capabilities. Certainly, Mr. Chief Justice, our evidence shows that federal prison officials are applying different disciplinary standards based explicitly on inmates' race and ethnicity. Under strict scrutiny analysis, as established in Loving v. Virginia and refined in subsequent cases, government actions that classify individuals by race must serve a compelling government interest and be narrowly tailored to achieve that interest. He paused, then continued with growing authority. The Bureau of Prisons claims their differential treatment serves security and administrative efficiency interests. However, our statistical analysis shows no correlation between these purported security benefits and the discriminatory practices. In fact, facilities with more equitable treatment show better safety outcomes. Roberts found himself nodding involuntarily. This analysis was sophisticated and well-reasoned. Moreover, Rock continued, even if we accepted their security rationale as compelling, which we don't, their methods fail the narrow tailoring requirement. Less discriminatory alternatives exist and have proven successful in state systems and international facilities. The revelation, Rock's hidden expertise, unfolds. Mr. Johnson, Roberts said, his tone now completely different from his initial condescension, your legal analysis is quite sophisticated. May I ask about your legal background? Rock smiled. Mr. Chief Justice, I've spent the last 23 years studying constitutional law. After my football career ended, I didn't just transition to entertainment. I began intensive legal studies, initially through Georgetown's continuing education programs, later through private study with constitutional scholars. I've worked directly with Professor Lawrence Tribe on 14th Amendment interpretation, studied under Professor Erwin Chemerinsky on federal constitutional law, and completed advanced coursework through Harvard's executive education program. I've read every major Supreme Court equal protection decision since 1868. The courtroom buzzed with surprise. Roberts himself looked genuinely shocked. Why did you keep this hidden? Roberts asked. Because people see my physique and entertainment career and make assumptions, Rock replied. I wanted to develop genuine expertise before revealing it. I didn't want to be dismissed as a celebrity playing lawyer. I wanted to be a lawyer in the truest sense. The depth test. Constitutional philosophy. Roberts decided to probe the deepest level. Mr. Johnson, what's your view on originalism versus living constitutionalism in interpreting the 14th Amendment? This question went to the heart of modern constitutional interpretation theory, the kind of sophisticated jurisprudential philosophy typically reserved for law professors and appellate judges. Rock's answer would demonstrate the true depth of his constitutional understanding. Mr. Chief Justice, that's the fundamental tension in modern constitutional interpretation, and I believe the 14th Amendment requires a nuanced approach that incorporates elements of both philosophies. He paused thoughtfully. The text and original public meaning of the Equal Protection Clause clearly intended to eliminate state-sanctioned racial discrimination. But the framers also wrote in broad aspirational language equal protection of the laws that suggests they intended the principle to evolve with changing circumstances. Roberts was now completely engaged, his earlier skepticism replaced by genuine intellectual curiosity. I would argue, Rock continued, that original intent supports applying equal protection more broadly than the specific historical context of post-Civil War racial dynamics. The framers chose expansive language precisely because they understood that equality principles would need to address forms of discrimination they couldn't fully anticipate. Roberts's complete transformation. The change in Chief Justice Roberts was remarkable and visible to everyone in the courtroom. His initial dismissive attitude had transformed into genuine respect and intellectual engagement. "Mr. Johnson," Roberts said, "I owe you an apology. I made unfounded assumptions about your capabilities based on your public persona. Your constitutional analysis is as sophisticated as any I've heard in this courtroom." "Thank you, Mr. Chief Justice," Rock replied graciously. "But I understand your initial skepticism. Our society often compartmentalizes people's abilities. I've been fortunate to pursue intellectual growth alongside my entertainment career." "Now," Roberts continued, "let's address your specific claims. You argue that statistical disparities in prison disciplinary actions constitute equal protection violations. What evidence standard should this court apply?" This question showed Roberts was now treating Johnson as a peer, engaging with his arguments on their merits rather than dismissing them based on preconceptions. The legal masterclass continues. "Mr. Chief Justice, I believe the appropriate standard comes from the court's decision in McCleskey v. Kemp, though I would argue for a more rigorous application than that case provided." Rock was now citing one of the most complex and controversial Supreme Court decisions, demonstrating knowledge that impressed even seasoned constitutional lawyers. McCleskey established that statistical evidence can prove discriminatory purpose, but set an extremely high bar. I would argue that when dealing with federal institutions, rather than the state death penalty system in McCleskey, we should apply a lower threshold because federal agencies have clearer constitutional obligations and better data collection capabilities. Roberts nodded thoughtfully. "Interesting distinction. Continue." "Our evidence shows disparities that exceed even the statistical significance thresholds discussed in McCleskey. Young black inmates receive disciplinary infractions at rates 340% higher than white inmates for identical behaviors. Hispanic inmates receive solitary confinement 275% more frequently for comparable infractions." Rock pulled out a comprehensive statistical analysis. "These aren't marginal differences explainable by legitimate factors. These are systemic patterns that demonstrate intentional discrimination." The precedent-setting moment. "Mr. Johnson," Roberts said, "assuming we accept your statistical evidence, what remedy do you seek?" "Mr. Chief Justice, we request declaratory and injunctive relief, requiring the Bureau of Prisons to implement constitutionally compliant disciplinary procedures with independent oversight. We're not seeking monetary damages. We want systematic reform." Roberts considered this carefully. "Your approach is measured and focused on constitutional compliance rather than punitive measures. This suggests genuine concern for legal principles rather than publicity." "Exactly, Mr. Chief Justice. This case is about ensuring that federal institutions uphold the constitutional principles they're sworn to protect. My celebrity status may have brought attention to the issue, but the legal arguments stand on their own merits." The government's dilemma. Deputy Attorney General Peterson, who had been quietly watching this exchange with growing concern, now found herself in an impossible position. Her strategy had been built around the assumption that Johnson was an amateur who could be easily dismissed. Instead, she faced a sophisticated constitutional argument presented by someone who clearly understood the law as well as her own team. Worse, the Chief Justice was obviously taking Johnson's arguments seriously. "Your Honor," Peterson interjected, "while Mr. Johnson's study of constitutional law is commendable, the government maintains that statistical disparities alone don't prove discriminatory intent." Roberts turned to her. "Counselor, have you reviewed Mr. Johnson's statistical analysis? The disparities he cites seem quite significant." Peterson realized she was now fighting an uphill battle against both a well-prepared opponent and a judge who had been impressed by that opponent's capabilities. Roberts's final assessment. As the hearing progressed, Chief Justice Roberts found himself in the unusual position of having his fundamental assumptions challenged and overturned. The Hollywood actor before him had demonstrated constitutional knowledge that rivaled veteran Supreme Court advocates. "Mr. Johnson," Roberts said as the hearing neared its conclusion, "your presentation today has been extraordinary. You've demonstrated that legal expertise can emerge from unexpected backgrounds and that intellectual curiosity and rigorous study matter more than traditional credentials." "Thank you, Mr. Chief Justice. I hope this case also demonstrates that constitutional principles are too important to be left only to traditional legal establishments. When fundamental rights are at stake, citizens from all backgrounds have a responsibility to engage with legal principles." Roberts nodded. "Indeed. This court will take your arguments under careful consideration. The constitutional issues you've raised merit serious examination." The ruling. A victory for constitutional principles. 3 weeks later, Chief Justice Roberts issued a comprehensive 47-page opinion that would reshape federal prison administration. The ruling found that the statistical evidence presented by Johnson demonstrated clear equal protection violations within the federal prison system. More significantly, Roberts's opinion included a remarkable footnote. This case demonstrates that constitutional wisdom can emerge from unexpected sources. Mr. Johnson's analysis of equal protection jurisprudence contributed significantly to this court's understanding of how constitutional principles apply to contemporary institutional discrimination. The broader impact. Changing perceptions. The Johnson v. Federal Bureau of Prisons decision sent shockwaves through both legal and entertainment communities. Law schools began studying Rock's constitutional arguments in their equal protection courses. The case became required reading for courses on constitutional litigation strategy. For the entertainment industry, the case revealed something unprecedented. A major Hollywood star who had secretly developed genuine expertise in constitutional law, not for publicity or career advancement, but from sincere intellectual curiosity and commitment to justice. Roberts' personal reflection. In interviews months later, Chief Justice Roberts would reflect on the case as a turning point in his own judicial philosophy. "The Johnson case taught me a valuable lesson about prejudice and assumption," Roberts told the American Bar Association. "I initially dismissed Mr. Johnson based on his public persona, assuming that entertainment success precluded serious intellectual achievement. I was profoundly wrong. More importantly," Roberts continued, "the case demonstrated that constitutional principles are most vibrant when engaged by citizens from diverse backgrounds who bring different perspectives to legal questions." Mr. Johnson's analysis was enhanced by his real-world understanding of institutional discrimination, combined with rigorous constitutional scholarship. The long-term legacy. The case established what legal scholars began calling the Johnson precedent, the principle that federal institutional discrimination could be proven through statistical evidence when combined with testimony about systemic practices. More broadly, it changed how the legal establishment viewed non-traditional legal advocates. Law schools began creating programs for accomplished professionals from other fields to develop legal expertise. The Supreme Court itself began more actively seeking amicus briefs from diverse voices beyond traditional legal organizations. For Rock himself, the victory was deeply personal. "I've achieved a lot in entertainment and business," he said in his only interview about the case, "but helping establish constitutional protections for vulnerable people, that's a different kind of success. That's about justice." The cultural shift. The case also sparked broader cultural conversations about assumptions and hidden talents. Social media exploded with discussions about judging people by their most visible achievements rather than their full intellectual capabilities. Universities reported increased enrollment in law courses from students in entertainment, sports, and other non-traditional backgrounds. The Rock model became shorthand for pursuing serious intellectual development regardless of one's primary career. The final word. 6 months after the decision, Chief Justice Roberts and Dwayne Johnson appeared together at a Georgetown law symposium on constitutional advocacy. Their mutual respect was evident to everyone present. "The Johnson case reminded me why I became a judge," Roberts told the audience. "Constitutional law is most meaningful when it protects real people from real injustices. Sometimes the most important legal arguments come from those who've experienced the consequences of legal failures firsthand." Rock's response encapsulated the broader lesson. Constitutional principles belong to all Americans, not just lawyers. When we engage seriously with these ideas, really study them, understand them, apply them, we strengthen democracy itself. That's work everyone can do, regardless of their day job. The case ultimately became more than a legal victory. It became a cultural moment that challenged assumptions about intellectual capability, demonstrated the power of rigorous self-education, and proved that constitutional wisdom could emerge from the most unexpected places. As Chief Justice Roberts had learned, sometimes the person you least expect to change your mind is exactly the person who will do so, if you're willing to listen past your preconceptions and engage with the substance of their arguments. The Rock had proven that true strength comes not just from physical power, but from the courage to pursue knowledge, challenge injustice, and stand up for constitutional principles, regardless of whether others think you belong in that fight. In the end, the biggest lesson wasn't about hidden law degrees or secret studies. It was about the danger of assumptions and the power of intellectual curiosity to transform both individuals and institutions. If you found this incredible story of hidden brilliance and constitutional justice inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected legal genius and the triumph of preparation over prejudice. Ring that notification bell so you never miss these extraordinary stories of how assumptions can be shattered and justice can emerge from the most surprising places. What did you think of Rock's constitutional expertise? Share your thoughts in the comments below.